of Ms Boothby, the Defamation Legislation Amendment Bill 2025, Serial 13, to move the bill be read a second time.
Attorney General.
Madam Speaker, I move the bill be read a second time.
I call the next member to speak in the debate. Member for Gwadja.
Thank you, Madam Speaker. Madam Speaker, the opposition will be supporting this bill. This bill was developed and drafted by the opposition when we were in government. So thank you for the government for acknowledging that we had done the hard work, Madam Speaker. This is an incredibly important area of reform, Madam Speaker, and we've seen right across the country all jurisdictions doing the work to make sure that our defamation laws are contemporised and are absolutely reflective of the world that we live in today. Madam Speaker, defamation law has always been about striking a balance on the one hand and protecting individuals from false and damaging statements, and on the other hand it's ensuring free speech, particularly in journalism and in public debate. It is not unduly restricted. This bill is significant because it implements both Stage 1 and Stage 2 reforms of the model defamation provisions, ensuring that the Northern Territory Government is aligned with the national approach to defamation law reform. From the outset, I will say that the opposition supports this bill as it was mainly developed and drafted by this opposition. In principle, because harmonising defamation laws across Australia is necessary, and we must ensure that our legal framework is up to date, fair and efficient and effective, particularly in an era where digital media and online communication has fundamentally changed the way information is shared and reputations are impacted. Harmonising our defamation laws also stops legal forum shopping when a party chooses a court to hear a case to get a favourable judgment. However, while we support these reforms, we also have questions for the government about the practical implications of these changes, especially regarding the serious harm threshold, the impact on individuals seeking redress, and the liability of digital platforms. I want to also outline the need for adequately resourced communications campaign to ensure that people across the Territory understand these changes. Madam Speaker, defamation laws in Australia have long been inconsistent across states and territory. The model defamation provisions were first introduced in 2005 to create a nationally consistent framework. However, over time, the rise of digital media, social media platforms and online content sharing has created new challenges. As politicians, all of us in this place would be aware of the sort of material that gets thrown around on the internet, often without repercussion. It can often, Madam Speaker, be a very ugly place, something that our laws didn't account for when first debated. In response, the Council of Attorney Generals, which I know our Attorney General fails to attend, initiated a review of defamation laws, leading a two-stage reform process. Stage 1, the 2020 reforms focused on early dispute resolution, strong defences and limiting trivial claims. Stage 2, the 2023 reforms addressed digital, Madam Speaker, liability and expanded absolute privilege to protect certain official reports. These reforms have been gradually adopted across the country, and today this bill, the Northern Territory, is set to follow suit. Labor, when in government, supported these national reforms, and I'm pleased to see them finally being implemented. Madam Speaker, this bill introduces several important reforms. As I have just outlined, these can be divided into two key parts, reflecting Stage 1 and Stage 2 reforms. Firstly, Stage 1 reforms introduce a serious harm threshold, meaning plaintiffs must prove significant reputational damage before proceeding with a defamation claim. This aims to filter out any trivial or vexatious claims, ensuring that only genuine cases go before the courts. However, we must consider whether this raises the bar too high for legitimate plaintiffs, particularly for individuals without the financial means to contest such a threshold. The bill also mandates a concerns notice before legal proceedings can commence, encouraging early resolution and reducing unnecessary litigation. Additionally, it introduces new defences, including a public interest defence and protection for peer-reviewed academic publications. The single publication rule is another significant change that addresses the publication problem in online defamation. This means the limitation period will begin from the first publication of defamatory content, rather than resetting each time the content is accessed. This prevents endless litigation over historical material, but also raises concerns about the redress for those defamed online, whether content can be amplified and persistently indefinitely. Stage 2 reforms focus on the liability of digital intermediaries, such as social media platforms and search engines. The bill exempts digital platforms from liability if their role is merely technical, such as providing caching services, search results, or passive hosting. However, platforms must take responsible steps to remove defamatory comment within 7 days of a complaint to be protected from liability. The bill also expands absolute privilege, granting legal immunity to reports made to police and other official bodies, ensuring that individuals can report misconduct without fear of defamation claims. As previously stated, Madam Speaker, the opposition acknowledges the importance of aligning with other jurisdictions. Thus, we will not be opposing this bill. Instead, we are responsible for scrutinising its details carefully and ensuring that these changes will work fairly and effectively for all Territorians. Madam Speaker, while the opposition supports the bill, there are key areas we seek clarification from the government to ensure these changes will work fairly and effectively for Territorians. 1. Will the serious harm threshold make it too difficult for ordinary people to sue for defamation? Have concerns been raised that this threshold favours well-resourced defendants, such as media organisations, at the expense of individuals? 2. How will victims of online defamation be protected? With a single publication rule, how will victims of defamation, particularly in digital spaces, be able to seek redress when harmful material remains online for years? Madam Speaker, will digital platforms be held accountable? The bill allows platforms to avoid liability if they act within 7 days, but mechanisms are in place to ensure they comply. Will there be consequences for platforms that ignore or delay responses to legitimate defamation claims? Are there safeguards to prevent the misuse of absolute privilege? While protecting whistleblowers is crucial, are there protections against malice or false complaints to police? Will these changes impact small media organisations and independent journalists? The public interest defence is intended to support responsible journalism, but what guidelines will courts use to determine reasonable belief in public interest reporting? Madam Speaker, during the Scrutiny Committee briefing on this policy, it was raised the need for clear public education, particularly for Aboriginal Territorians, multicultural communities who may not be aware of these legal changes. The legal landscape surrounding defamation law is complex. Even before these amendments, many Territorians were not fully aware of their rights and responsibilities under defamation law. With this bill introducing new thresholds, new defences and new legal procedures, the government must ensure that all members of the community understand these changes. In particular, we must recognise that many Aboriginal Territorians speak English as a second, third, fourth or even fifth language. Many migrant and refugee communities may not be familiar with defamation law or legal terminology. Digital platforms are often the primary source of information in these communities, yet they are also the main arena where defamation issues arise. The opposition calls on the government to commit to a public education strategy that ensures that these reforms are communicated clearly, accessibly and culturally appropriate. This should include multilingual resources explaining how the new defamation laws work, particularly in Aboriginal languages and key community languages such as Greek, Filipino, Mandarin and Vietnamese. Community engagement through local organisations, legal aid services and interpreters to ensure that those with limited English are not disadvantaged. workshops or legal clinics in remote communities where access to mainstream legal information is often limited, and clear, plain English guidance on how serious harm thresholds work and what steps individuals can take if they believe they have been defamed. Madam Speaker, defamation law should be accessible to all Territorians, not just those with legal expertise or strong English literacy. If the government is committed to ensuring fair access to justice, it must also be committed to ensuring these laws are adequately understood by the communities most likely to be affected. This bill represents a much-needed update to our defamation laws. It brings the Northern Territory legislation in line with national standards, protects public interest reporting, and recognises the reality of digital communication in today's world. As I've already said, we must ensure that these reforms do not unfairly disadvantage individuals, that digital platforms act responsibly, and that access to justice remains fair and accessible for all. The opposition will continue to monitor how these laws are implemented and seek clarification from the government to ensure they function as intended. We support this bill for now, but we urge the government to address the legitimate concerns we've raised today. Thank you, Madam Speaker.
Member for Fong Lim.
Thank you, Madam Speaker. I'm delighted to have the opportunity to discuss this bill today, which has been on the notice paper for some time. And also pleased that the opposition has chosen to support the bill, but also to provide some pointed remarks about the bill. And it is true that these are long overdue reforms. And what's astonishing to me is that the opposition would raise this matter now and suggest that the oppositions are overdue for any reason other than their own inability to actually implement the reforms. The Stage 1 reforms were passed in 2020. And every state and territory in the country, bar WA's, actually got them in place. We're the only ones that haven't done it, and it's because the former government never saw fit to make it a priority. Now, we are passing legislation at a rate of knots around here. Some of it is happening faster than people would like. But on issues like this, which are relatively uncontroversial, generally decided upon by both sides of Parliament as a useful thing to do, we haven't made any progress at all. Now, look, we've just picked out some very niche, we've just heard some extremely niche critiques of what might be problematic about these defamation model provisions. I think it's useful to zoom out and just understand the bigger picture here of what this is, what it's going to do, why it's a good thing, and perhaps that will lay a groundwork for how we might proceed in relation to doing legislative reform in other important areas. So first up, for the uninitiated, defamation is a body of law that aims to protect individuals, groups and entities from the publication of false and damaging statements that can cause harm to reputation or standing in society. And so what does it take to do that? Well, an action in defamation requires a number of things. First of all, it requires proof of statements that have been communicated by publishing to a third party, whether those things are written or they're spoken or they're electronic. Similarly, it requires that those statements identify or be about a plaintiff, and also that they be actually defamatory and of cause or are likely to cause the plaintiff harm because of a negative claim about the plaintiff. Now, in the Northern Territory, we have defamation law, of course. We have the Defamation Act 2006, which is the act that promotes uniform application of defamation in Australia. Now, the objects of the act that we had at the moment, aside from promoting uniformity, are to ensure that the law of defamation doesn't place any unreasonable limits on freedom of expression, and in particular on the publication and discussion of important matters of public interest and importance, and also to provide effective and fair remedies for persons whose reputations are harmed by the publication of defamatory matter, and also to promote speedy and non-litigious methods of resolving disputes about the publication of defamatory matter. Now, it's worth laying that as a foundation, because what we just heard now, you would think that, defamation law was going to be remade into something new, whereas in actual fact, the existing Defamation Act does seek to ensure the law doesn't place unreasonable limits on freedom of expression, fair remedies are provided, non-litigious conflict resolution options are also built in within. So why are we doing this? Why is this a good thing? Why is it that the rest of the country already thought about this and got on with it a long time ago? Well, it's because of the virtues of building upon model legislation to create uniformity, because the idea is model laws lead to model justice. And so in other parts of the country, stage 1 reforms have been implemented long ago, and stage 2 reforms haven't been uniformly implemented. And if we were to implement both by enacting this bill, then the Northern Territory would become the 4th jurisdiction in actual fact to implement both stage 1 and 2 of defamation reform. If we step back a step, what's this all based on? Well, it's the model defamation provisions. And so in November 2004, the model defamation provisions were discussed by the Standing Council on Attorney Generals, and that's what led to our 2006 Act. So more often than not, when we do sensible things in the law here, it's not by being vanguard and too bolshy, it's by actually seeing what's happening in other places where perhaps there are more access to resources to fairly consider what might be done. And then once we've had the benefit of that wisdom, then also making things work in our local context. And that's exactly what happened with our 2006 provisions. That, of course, doesn't exonerate the former government from failing to do anything with the stage 1 reforms for the last 4 years. But I digress. The Standing Council on Attorney Generals then in 2018 met again to say perhaps we should review those model defamation provisions. And that led to a 2-stage review process, which, as has been alluded to, was a stage 1 and stage 2 process. And so stage 1 was led by New South Wales predominantly, and they also were involved in part A of stage 2. And that was about the Model Defamations Amendment Provisions 2020, and Victoria led the stage 2 reforms, if you like, the part B. Now, the overall benefit of this package of stuff is to eliminate forum shopping and to allow the law to better capture the challenges of the digital age with regards to social media in particular. And this is the part where everybody in this House should pay attention. Because for the most part, defamation law, not my problem, not going to be an issue for me, not really paying attention, we've all agreed, let's vote on it. No, 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 no. There was a very important High Court case called Voller in 2021. And Voller is really the law that, we need to be apprised of in this place because it determines what can and can't be determined defamatory now in the context of the digital age. Different standards apply on Facebook, then on Instagram, then on your website, then on a Google search engine. And so all of what you end up doing in your everyday political lives now is up for challenge for defamation, and the rules and standards are incredibly different. So if I had one takeaway piece of advice, it would be that everybody have a little look at the Voller High Court case. Now, basically what the stage 2 reforms do, or one of the primary objectives of them, is to limit the effect of the High Court decision of Australia in Fairfax Media Publications and others v. Voller 2021, 273 CLI 346, especially with respect to what the reforms describe as digital intermediaries. So there's now effectively a new defence for digital intermediaries for online third-party content. In Voller, third parties left allegedly defamatory content about Mr Voller on posts made on Facebook pages of 3 media organisations. And the High Court found that these media companies could be sued in defamation as publishers of those third-party comments. Now, what's the benefit of the Stage 2 reforms? Well, under the Stage 2 reforms, a person or entity will be a digital intermediary if they provide or administer an online service, for example, a website or a social media platform, where a defamatory digital matter is published, provided they are not the author, originator or poster of the matter. So in response to Voller, the reforms create a new digital defence for digital intermediaries who will not be liable for an action in defamation if firstly they can prove that they have an accessible complaints mechanism, which is the defence here that the member for Guaja should be interested in, to receive written complaints about defamatory content on their online platform, for example, an email address or complaint submission web page. And secondly, that they, assuming the written complaint is in a form that complies with the applicable legislation, they prove that they took reasonable access prevention steps to remove or block, disable or prevent access to any such matter within 7 days of receiving the complaint. Now, this defence can still be defeated if the digital intermediary is motivated by malice and in providing the online platform by which the defamatory matter came to be published. I'm sorry, Member for Guaja, am I interrupting you? No, I was just double-checking. Separately, separately...
I think he's finished.
Please, take your seat, Member for Guaja.
I'm happy to put Standing Order 44.
Take your seat. Standing Order...
Yep, I move that the question be put.
The question is that the motion be put. All of those in favour say aye. Aye. To the contrary, no. I think the noes have it. Please, member for Fong Lim, continue and let's pay him some respect.
That's actually, I'm actually a little bit sad about that. I can't believe that a member would cease to gag debate on something that is actually important legislative reform. I'm sorry that it's boring you to have to do real legal work that you failed to do in your term as the Attorney General. Separately,
Member for Gwaja, you're on a warning.
Separately, Madam Speaker, a digital intermediary providing caching, conduit or storage services would be exempt from the liability if they publish any defamatory matter in the course of providing those services. Now, that exemption will not be available to a digital intermediary that participates in or encourages or promotes the publication of that defamatory matter unless they're required to do so by law or a court tribunal order. So these are important changes that bring us into line with the rest of the country. They put us in line with best practice. These are important things to consider, and it's laughable to think that they're not worthy of discussion here because it doesn't provide an opportunity for the opposition to grandstand. There are exemptions also for search engine providers for search engine results, which is another thing that is very important now, because the exemptions draw on the findings of the majority of the court, the High Court that is, again, in Google versus Defteros 2022, where Google was found not to be a publisher of defamatory news articles by reasons of a search result, including a hyperlink to that article. So these are actually bringing us into the modern standard, into the modern world. You want laws that reflect modern standards, best practice, then pay attention. The expansion of absolute privilege defence to defamatory publications made to police is also a really important one, especially if you're concerned about people being able to make statements against the police. This reform is intended to provide greater comfort to persons making reports to police, and that is an important thing to be able to provide, in that they will not be liable in defamation if they make a police report about someone. Practitioners advising clients, will know that the subject of a police matter is a serious thing, and they should be mindful of this, and this will afford people making the report with a complete defence to any potential defamation claim. Another thing where defamation law frequently falls down is the service of notices. And under the Stage 2 reforms, a notice can now be validly served electronically, which is extremely important because you can send it by email, by message, by other electronic communication to make sure that a recipient has received it for the purpose of giving or receiving documents on them. The fact is, defamation laws are not uniform across the country. And this is an opportunity for the Northern Territory to enact the Stage 1 reforms, which it should have done long ago but failed to do because of the ineptitude of the former government. This is also a chance for us, though, to get ahead of the curve by enacting the Stage 2 reforms. We'll actually only be the fourth jurisdiction in the country to catch up to the digital age, which is increasingly important for us to do. I won't say terribly much more other than to note that as I say, the Stage 1 reforms benefit us in a number of ways. They address the standard of serious harm, something that should have been done long ago. They mandate concerns notices prior to proceedings, which should have been done long ago. Defences for public interest and peer-reviewed publications, which should have been done long ago. The Stage 2 reform benefits will also include things like the new innocent dissemination defence. Now, I won't say anything more for fear of imposing on the opposition any further on having a substantive debate. But what I would say is that the Attorney-General's second reading speech was very comprehensive, as was the explanatory statement. This was one of the better explanatory statements that we've seen in here recently, as distinct from half of the ones that I found typographical errors from the previous government because it was a lazy process that they ran. The amendments will likely streamline court processes and will improve the legal test for damage to the plaintiff. Now, I support working cooperatively in this place, and I'm frustrated by the fact that at the moment, most of what we're doing here is like playing chess with pigeons. It's ridiculous. People just defecating on the board and kicking the pieces over. Act like a goddamn grown-up. I support the move towards consistency and creating harmonisation of law with other jurisdictions. I commend the Defamation Legislation Amendment Bill 2025 to the House, and I hope that you will all take very seriously these changes, which are important legal changes to make to improve our legal edifice. Thank you very much, Madam Speaker.
Attorney-General, in closing debate.
Thank you, Madam Speaker, and I thank all of those members who contributed to this very important debate on defamation legislation amendment, Bill 2025, as part of our government's legal reform agenda. And thank you, Member for Fong Lim, for pointing out that you're right. This legislation has been sitting around. It was finished a very, very long time ago, but it never got over the line. It never got on the agenda, and it was never passed by the former government, which is really interesting because the two members that are in opposition right now, they were both former Attorney Generals. So I do thank, though, the member for Gwadja for his contribution about the legislation, and thank you for supporting the bill and stating that you're going to support the bill. I think that's it makes for really good bipartisanship, because we don't always agree on everything, but if we agree on this, then that's a good thing. So, Madam Speaker, I also want to thank the Legislative Scrutiny Committee for the careful consideration of the bill, and of course they published a report on the 5th of March 2025 supporting passage of this bill, and it Madam Speaker, the bill will prevent our legal system from being overburdened by minor matters. It protects Territorians from unnecessary legal battles over trivial disputes, and it brings the Northern Territory up to date with best practice defamation reforms. So I also would like to thank the Attorney General's Department, who had spent a long time previously putting all this together and then, of course, briefed us when we came to government. And I note that they have prepared a very comprehensive set of education materials, including a fact sheet for the changes in defamation, which was a question that the opposition asked about. And, of course, that'll assist with understanding the changes. So, Madam Speaker, I thank all the members of this House, and I seek leave to move the third reading.
The question is second reading. We're only up to the second reading. The question is the bill be now read a second time. Those of that opinion say aye. To the contrary, no. I think the ayes have it. The clerk.
A bill for an act to amend the Defamation Act 2006, the Limitation Act 1981 and the Local Court Criminal Procedure Act 1928.
Minister.
Madam Speaker, I seek leave to move the third reading.
Is leave granted? Minister.
Madam Speaker, I move that the bill now be read a third time.
The question is that the bill be now read a third time. Those of that opinion say aye. To the contrary, no. I think the ayes have it. The clerk.
A bill for an act to amend the Defamation Act 2006, the Limitation Act 1981 and the Local Court Criminal Procedure Act 1928.